Hi, everybody. Thanks for joining. We're due to start at 2 o'clock, so we'll hang on at least another minute, if not a few seconds beyond that, just to allow everybody the opportunity to join. So thank you to those that are just joining. We're due to start at 2 o'clock. We're not quite at 2 o'clock yet, but we'll hang on just a few seconds beyond that, just to give everybody plenty of time to come on in and join us. Hope everybody's okay this afternoon. Thank you to those that are joining us. We're just going to hang on a few seconds more just to give more opportunity for people to join us. Okay, thank you to those that are joining us. I'm just hanging on a few seconds longer before we get started, just to give people the opportunity to join, because I can see there's people still joining us at the moment. So we'll just hang on a few more seconds just as people are joining. Okay, I can see people are still joining us at the moment. But I'm going to get started. So thank you to everybody who's joining us this afternoon for this session, which is Essential HR for Small Charities. My name's Alison Smith. I am the CEO and a lead consultant at Roots Human Resources, and I'm going to be delivering this webinar for you today, which is hopefully going to give you a sort of an awareness of main employment rights for employees within your organisation, and will give you sort of guidance and signposting for further support, typically around sort of managing employment situations that arise during the course of employment with you. We ourselves, Roots HR, we're a social enterprise ourselves. We're the only HR consultancy in the UK that uses our trading services to provide free HR services and free HR learning and development to leaders and managers working in the social sector. And last year, we were able to fund free HR support that was valued at over £900,000. So we're delighted to be with you today, part of Small Charity Week. This webinar today, and I delivered the same webinar on Tuesday, is fully funded, being delivered as part of our Social Impact Fund and as part of our social purpose, which is all about developing people management knowledge and skills in the sector. So it's great to have you all here today. Just a little bit of housekeeping. We've got Q&A enabled for this particular webinar. So hopefully you'll see that either at the top or the bottom of your screen. So if you have questions as we go through, feel free to pop them in the Q&A. If I can't get to them as we're going through the session, then we'll have an opportunity just to pick up on any questions at the end. I'm running solo today. Normally I have a sort of another member of staff, another team member with me as support, but we've got leave and other learning and development activities ongoing at the moment. So if you raise a question in the Q&A, if I don't get to it as we're going through the session, there's opportunity at the end for those to be raised. So what we're going to cover today is, as I say, just really main employment rights for employees, and particularly those within small charities. I'm going to touch on main employment rights, but I'll signpost you to additional materials or guidance that would be helpful to cover all employment rights, because we would be here for a long time if we were going to cover off each and every single one of them. I'm going to talk to you about likely impacts of the Employment Rights Bill, and I can give you a hot off the press update as to where that bit of legislation is in Parliament at the moment and when we think it's going to become an act, when it's going to get royal assent. And then we'll cover off at the end some sort of typical situations that can arise during the course of employment and talk through those. So I'm going to start with looking at this bit of minimum compliance around these sort of main employment rights for employees. So say this is not a full list that I'm going to go through, but it's the main ones. And I've actually highlighted on this slide, you will get a copy of the slides after the presentation today, that we have a fact sheet that's called Starting to Employ. I'll actually send you a copy of the fact sheet along with the slides, but the link that's on this slide, you can request a copy of the fact sheet, but actually that takes you through to the page on our website where you can actually request any and all of the fact sheets that we have on offer. So but I will send you through the one that I refer to on the slide along with a copy of these slides after the session. It might be tomorrow when that comes out to you. So let's start at the top of this this diagram with contractual. So as an organisation, as an employer, you must provide a written statement of terms and conditions of employment from day one of employment. So if you recruit an employee by no later than their first day of working with you, you must have provided them with a written statement of terms and conditions of employment. Typically that's set out in a contract of employment. Sometimes that full statement is made up of the contract of employment plus other documents. So it may be offer letter, handbook might actually form part of that statement, but that has to be provided no later than day one of employment. And obviously there are typically things that you will do pre-employment. That's why we refer to them as pre-employment checks. So it's not part of this minimum compliance, but I do want to highlight that probably in advance of issuing a contract, you'll be doing things as well, like right to work in the UK checks, maybe DBS checks, depending on the nature of the work the post holder will be doing, employment references, etc. When it comes to paying benefits for your employees, and the focus of this session is around your employees, we're not talking about sort of volunteers or contractors in this session, but you have to comply with national minimum wage, and this includes the national living wage. So these are the rates that are set annually by the government. There is a separate voluntary living wage that organisations can sign up to, but the absolute statutory minimum that you must comply with is the national minimum wage. And as I hope you're aware, those rates increase annually, and those increases take effect in April of each year. It coincides with the start of the new tax year. You should also comply with pension auto-enrolment, which is the provision of a workplace pension. And you will have people who will be automatically eligible to be automatically enrolled in the scheme. You may also have workers or job holders who could be eligible to apply to join the scheme. There are also sort of statutory benefits and or payments, and sometimes there might be eligibility requirements for individuals to meet for those. And that would include things such as maternity, paternity, shared parental leave and pay. So some of those are family leave orientated, but also other types of statutory benefits, including things such as statutory sick pay, statutory redundancy pay, and also statutory notice periods. So the minimum period of notice that must be given if you were ending employment. Now, that might be enhanced by anything that's set out within your contract, but there is a statutory period. But as I say, some of those statutory benefits and or the payments associated with them have eligibility requirements. And at the end, in one of the slides at the end of this session, I put a link to the gov.uk website. It's actually some really helpful guidance for employers on there. And if you've been on the website, hopefully you'll agree that it is written in sort of plain English, and some of the guidance, particularly around things like these statutory benefits, family leave, is very, very helpful. So I've signposted you to those on a slide towards the end of this session. There are also statutory requirements around working time and leave. So we have the working time regulations, which were brought into UK law post-Brexit, because they were originally European law. And that covers sort of maximum working hours that an individual can work. It provides requirements on you in regard to break periods that people have, and also the times between shifts or sort of working days. And of course, it sets out entitlement to annual leave for your employees as well. So the minimum standard, or minimum level, I should say, of annual leave is 5.6 weeks per year. That would be for a full-time employee, which would be prorated for anybody who might work part-time or might work part of the year, for example, on term-time contracts. So 5.6 weeks equates to 28 days. Now that 28 days can include the statutory bank holidays. So it could be 28 days inclusive of statutory bank holidays. A lot of employers in the sector will give annual leave that's greater than that. And that's absolutely fine. Contractually, you can do that, but just this is the absolute statutory minimum that you must offer. So for your full-time employee, 5.6 weeks annual leave per year. There's also, again, some statutory rights to time off, again, if particular eligibility requirements are made. Some of those include the family leave that we've touched on previously, maternity, adoption, paternity, etc. But there's also right to unpaid carers leave. So that's up to 5 days leave in a year, unpaid for somebody who has caring responsibility. There's a right to parental bereavement leave. That's a statutory bereavement leave in the loss of a child. And as introduced in April of this year, so April 2025, there is a statutory right to neonatal care leave and pay. And that's for anybody who has a child who has to receive neonatal care. And it's additional leave in addition to the entitlements they may already have to family leave. There's also unpaid time off for what's called emergency care for sort of dependents, typically referred to as sort of emergency leave, and time off for public duties. There are some new entitlements to statutory leave that are going to be added, and I'll talk about those as we touch on the Employment Rights Bill. There's also, in regards to working time, a right for individuals to request flexible working. That's a right to request. It's not the right to work flexibly. Again, there are some changes that are due to be made to that through the Employment Rights Bill. From a health and safety perspective, and I'll caveat this by saying we're not health and safety consultants, but I've got an understanding of sort of the minimum compliance in regard to health and safety when it comes to your sort of workforce. As an employer, you owe a duty of reasonable care to your employees. So you have a reasonable or a duty to select competent individuals to undertake roles and to provide them with adequate materials and resources to undertake their work and to provide safe systems of work. What that looks like is obviously going to very much depend upon the type of organisation that you are, the type of work that individuals are doing there. You know, something is going to look very different for an office-based person to somebody who's based in a retail environment or a warehouse or a cafe. So it's going to be different. Those sort of safe systems of work and the resources required to do the work are going to be different. But you have an obligation to essentially provide healthy and safe workplace for your employees. You do need to display or issue either a health and safety policy or a health and safety leaflet, and that should be displayed or issued so all staff can access that. And if you have 5 or more workers, so if you've got employees 5 or more or workers 5 or more, then you are legally required to have a health and safety policy in place. In terms of discrimination, employees have the right not to be discriminated against. Under the Equality Act, this is in regard to protected characteristics. So there are 9 protected characteristics in law that include things like age, race, sex, religion, disability, gender reassignment. So there's 9 protected characteristics that are set out in law. And the law sets out the types of discrimination that are prohibited. So you may have heard of some of them: direct discrimination, indirect discrimination, harassment, victimization. There's also discrimination by association, which, as an example, if as an employer you decided not to recruit a candidate that you interviewed because they happened to mention that they had a disabled child, and your decision not to recruit them or not to offer employment was on the basis that you believed that having a disabled child would mean that they would have more time off work, then although that individual that you've not employed doesn't themselves have a disability, you could potentially be discriminating against them through their association with a disabled individual, i.e. a disabled child. And there's also discrimination by perception, which again means that you don't yourself have to, the individual themselves doesn't have to have the protected characteristic, but they could be perceived by others to have that. So there's all, discrimination. It's a big topic. We have, again, webinars and things on our website that cover the topic in more detail, and we'll cover you through things such as recruitment and selection and avoiding unconscious bias. But outside of the Equality Act, there's also other legislation. So, for example, if you have part-time employees or workers, if you have fixed-term employees or workers, then there is different pieces of legislation that set out that those workers should be treated no less favourably than comparable full-time employees. So there is legislation that covers, for example, the benefits, the terms that they're offered, and for fixed term employees, that should be no less favourable overall when compared to employees on permanent contracts. So there's different legislation that covers different types of discrimination. But obviously the main legislation that you've probably heard of is the Equality Act, which is where it sets out the 9 characteristics, protected characteristics, which it's unlawful to discriminate against. There are some exceptions that are set out within the law, but again, if you have a look through our website at some of our free resources, we go into that kind of level of detail in a lot more detail when we're running focus sessions around discrimination or harassment, bullying and harassment, etc. Finally, on this slide, in terms of the sort of little circles, we've got data. Now, this session we're running in regard to HR essentials. So obviously, when I'm talking about data, I'm talking about it through the lens of your workforce, your employee data. Again, post-Brexit, GDPR, the European legislation, was brought into law in the UK, and we refer to it now as UK GDPR. So you have a requirement to ensure that your processing of your workforce personal data is in line with UK GDPR. Now, obviously, you are likely to be processing a lot more than just your workforce data. You might have service user data, supplier data, etc. So you'll need to think about your data protection processes and policies for that type of data as well. But for the purposes of this session, then we would highlight the need for you to have perhaps a policy or processes that ensure that your processing of workforce data is compliant with UK GDPR. There are other employment rights that are included. Again, this is not an exhaustive list, but I'll just highlight a few of them. There's the right to not be unfairly dismissed. Now, at the moment, there is a 2-year length of service requirement to bring that type of claim to an employment tribunal, but I'll reference the changes that are likely to come to that with the Employment Rights Bill shortly. A new piece of legislation was introduced in October 2024, which is called the Worker Protection Act. And that placed additional obligations on employers to take reasonable steps to prevent harassment, including sexual harassment in the workplace. And again, those duties are going to be extended through the Employment Rights Bill. So I'll touch on that as we come on to the Employment Rights Bill. But if you haven't yet sort of started to look at reasonable steps to prevent harassment in the workplace, again, there's some guidance on our website through our blogs and quarterly employment law bulletins that would hopefully give you a starting point as to what reasonable steps to prevent harassment might look like in a workplace. So sort of thinking about this minimum compliance, question we often get asked is what sort of HR documentation and what HR policies should I have in place? So we touched on at the start when talking about contractual, obviously the requirement to issue a written statement of terms and conditions of employment. So you need to have that in place, and that will quite often, be provided in the form of a written contract of employment. And we said as well that, you must have either as a minimum a health and safety poster or a health and safety leaflet and risk assessments done. If you don't have a health and safety policy, if you've got fewer than 5 employees, you can get health and safety leaflets from the Health and Safety Executive website, and they can be, physically put up in workplaces, or you can make them available online for people. But when thinking about policies, as we've just said, 5 or more workers, you're going to be legally required to have a health and safety policy in place. So, that can dictate to you one policy that you may need to have in place. Other than that, we recommend that you start thinking about a number of things that happen within your organisation. So what's the typical risks that you might have within your organisation? Do you have a risk register? Are there risks identified that would benefit from having a policy in place? Are you managing recurring situations in respect of your workforce that, again, might infer that you would benefit from having a policy to cover that situation? You may have commissioners or funders who have a requirement for you to have particular HR policies in place. Equality and diversity is a key one there that people will ask for. And there might be things that, sort of once you've got your basics in place, if you start to think about, we want to be an employer of choice, we want to think about how we can attract people to the organisation, that you might start developing policies that would help in that situation. But as an absolute minimum, what we would typically sort of recommend is, firstly, your equality and diversity policy. They're really to sort of set out your principles and your approach to sort of inclusivity in the workplace. As we said, health and safety, if you've got 5 or more workers, then you're required to have that health and safety policy in place. Some form of policy around use of IT can be very helpful, setting standards around acceptable usage, really to protect your sort of resources, protect data security. Sometimes it can be reputational, sort of managing risk. But, when we have more and more people who are using things, platforms like social media, we've got things like the growth of generative AI, then it can be really helpful to have, IT policies in place that will give you some, standards there, articulate the standards and expectations that you've got of your workforce. Things such as managing absence and different types of leave can be helpful. We touched on a question thinking about recurring situations that you have, leave and absence is always a sort of a recurring situation. Thinking about having a policy in place will give you, not only allow employees to understand what the procedures are, but also your managers as well, so that, again, there can be some consistency in approach as to how your organisation is managing absence or managing leave. As we've talked about, data protection, so we'd kind of recommend that you have a policy in place around your handling of personal data. And then, just based on the implementation of the Worker Protection Act last year, and the obligations that are likely to come through the Employment Rights Bill, then we'd recommend a policy, either anti-harassment, harassment and bullying, bullying and harassment policy, that sets out some of the reasonable steps that the organisation will take to prevent harassment. Ideally, what you want sort of well-written policies. Are you really having them in place to give you a framework that's going to allow your managers in particular to ensure fairness and consistency in terms of how they're handling some of the sort of typical employment situations that we'll go through during this session. So those are probably the 6 that we would sort of get you to think about whether you need those in your organisation. It may be that you legally are required to have a health and safety policy, but as I say, we'd encourage you to think about, you know, what risks there are in your organisation, what are your recurring situations, do you have any funder or commissioner requirements, and then once you've got your basics in place, it may be more then thinking about how you can enhance the overall employment proposition, not only for retention for existing staff, but also as attraction for sort of new staff. So what I want to do now is sort of touch on what is likely to come through from the Employment Rights Bill. Now, this is all as of today's date. This is all caveated with lots of question marks and can be potentially subject to change. The Employment Rights Bill itself is going to be the biggest change in employment law for decades, probably. But there's a lot of it that we still don't know, and some of it that will require secondary legislation. So this means that even when the Employment Rights Bill gets royal assent, some of these changes, it's not going to be, sort of implemented overnight. And there will be some of the proposed changes in the bill that will require consultation and will require secondary legislation. In terms of what's happening now, the bill is in the House of Lords at the moment. So it has literally just, as at I think 10:30 p.m. on the 24th of June, it finished the committee stage at the House of Lords. There now has to be a report and a final reading of the bill in the House of Lords before it goes back to the House of Commons for sort of final rubber stamping, and then to be presented to the King for royal assent. The reason I raise that is that Parliament is due to go on recess on the 24th of July. So as at today's date, it's probably more unlikely than likely that royal assent won't happen before the summer recess. So as at today, it's probably, can't guarantee, but it's probably more likely that royal assent will happen once Parliament returns in September. So this is why some of this is in question marks, but also, you know, as I say, there's still a lot that we don't know, even once the bill itself gets royal assent. So as at today, likely that it won't get royal assent until September. But, you know, we may be surprised. It may happen before the 24th of July. But what will happen once the bill gets royal assent is that there are some things which don't require secondary legislation, which could be essentially ready to go and which the government could implement, not necessarily overnight, but relatively quickly. If the bill got royal assent in July, I would anticipate some of these changes would probably start to come into play in October. If it doesn't get royal assent until July, it may be that we're looking at slightly beyond October for changes to come into place. I would still expect them to be relatively fast moving, but the two that at the moment, based on information that we're hearing from key employment lawyers and barristers, is that there are two changes that are likely to be relatively quick to implement. So it may be that from sort of October onwards, perhaps October into the winter period, that we can see these come in. The first one is changes to fire and rehire. The second one is increased protection from harassment, including sexual harassment. So fire and rehire is typically where a after a period of consultation with employees to change contracts of employment. If changes are not accepted by employees, there was sort of always a last case scenario that could be that you could in effect dismiss the individual from their existing contract and then immediately re-engage them on a new contract on the changed terms and conditions. There were still risks associated with that. Fire and rehire has had very bad negative press through some sort of probably more than likely unscrupulous ways that it had been used, not in our sector, but, you know, P&O, you would have heard that was more fire and replace, but, you know, it's had some very bad press. The way that the Employment Rights Bill is going to work, because none of the amendments from the House of Lords have been accepted, is that there is going to be an extremely narrow allowable time when you could fairly fire and rehire, and in essence that's going to be the sort of imminent financial collapse of the organisation. What that means is that it could potentially become a lot more difficult to go through a consultation period to enact changes to terms and conditions of employment, because you wouldn't have that last sort of step available of being able to fire and then automatically re-engage on new terms. What that means is in essence, there are some things that potentially you could look to do now. And I would say, you know, consider if you do have terms within your contract of employment that allow you to vary a contract, look at the wording in there, perhaps take some advice to see if there are other terms that or other wording that should go in the contract. Obviously, you'd need to get agreement to vary those contractual clauses. But changes to fire and rehire are coming, and they're going to come quickly, along with what I referred to as kind of the next steps. So the Worker Protection Act basically said that you have to take reasonable steps to prevent harassment, including harassment from third parties. The Employment Rights Bill and what's within there now will set out that you have to take all reasonable steps. And that's why I'm encouraging you to look at a policy, because if you look at the guidance from the Equality and Human Rights Commission, they set out 8 steps that they would say are reasonable for an employer to take. The first one is have a policy. So again, steps to take now. Looking at the organisation, do you have a policy that covers harassment, including sexual harassment? If not, that would be where I would suggest you start. Again, subject to timing of royal assent, there are some changes around some of the statutory benefits that we talked about. Put that these might come into place from April of 2026. That's because most changes to statutory benefits and statutory levels of pay happen to coincide with the start of a new tax year. So that's when I'd anticipate these may come in. So there are going to be day one rights increased for paternity leave. There's going to be a right to bereavement leave. So whether this is paid or unpaid, we don't know as yet, but the introduction of a bereavement leave that is separate to parental bereavement leave. So that means if an employee suffers a bereavement, again, definition is needed here of somebody close to them. So perhaps a spouse, a parent, you know, a sibling, that they would have the right to a statutory period of bereavement leave, likely to be a week. We don't know whether that's paid or unpaid. And then some changes to statutory sick pay, which is essentially removing the 3 waiting days. So statutory sick pay could be paid from day one of a period of sickness absence. Again, we think that this is going to happen in autumn 2026 because it's kind of been set out in the bill that it will be, which is the removal of the 2-year length of service requirement for an individual to bring a claim of unfair dismissal to an employment tribunal. So this relates to an unfair dismissal claim only. So this would essentially mean that from day one of employment, any individual would have the right to claim unfair dismissal. So there's no length of service. We say on the slide that the clock is already ticking on this because if you recruited somebody today, say June 2025, by the time we get to autumn 2026, and when we say autumn, typically from a government point of view, changes will typically come in October. So say by the time we get to October of 2026, they will have, what is it, 15 months service with you, but at that point they would gain the right to claim unfair dismissal. So even now, employees that you're recruiting now will not need to wait 2 years from the date that they started. You know, if they start with you now, essentially they've only got 15 months or so length of service required before they can bring unfair dismissal claims. But from autumn 2026, there will be no length of service requirement. Beyond that, there's lots of other changes that the government are going to bring in that are in the Act or the bill as it is at the moment. That includes things like extending the time limits for individuals to submit claims to employment tribunals. Looks like that's going to change from the 3 months as it currently stands to 6 months. So somebody would have a 6-month period to bring a claim to an employment tribunal. Changes to collective consultation. Now that would only impact if you were consulting with a larger group, so 20 or more roles that you were seeking to make redundant. Changes to 0 hours contracts. Now, I've just put 0 hours contracts here because trying to articulate what the proposed changes are would be substantial. And again, at the moment, I'm not quite sure. This 0 hours contracts and the proposed changes is going to need secondary legislation. It's going to need consultation. It's not going to be an overnight change. Whether they will start consultation on this next year, which means that, you know, we could be looking at, you know, 2027 beyond before anything is in secondary legislation and being implemented, and because at the moment I don't know what is being proposed around changes to 0 hours contracts and the right for people to kind of request you know, more reliable hours is going to work in practice. So that's still very much up in the air. So even if the bill gets royal assent, becomes an act, there will be need for consultation and there will be secondary legislation, particularly in areas such as 0 hours contracts. As I say, some of these changes are not going to be overnight. Implementation of a Fair Work Agency, again, how that's going to work, how it's going to sit alongside existing things such as employment tribunals and ACAS, unclear at the moment. And there are going to be some increased trade union rights. What I would say is it's going to be really important for you to be aware of the changes, what's happening. So I would encourage you to go onto our website, sign up to our newsletter. You will get our newsletters, our quarterly employment law bulletins. You will also find out when we will be running webinars and other updates around the Employment Rights Bill. We are thinking that we're likely to run some kind of webinar around September time, which will obviously be hopefully once the bill has got royal assent and we've got a bit more of an understanding as to what are the changes that are going to happen first. So again, if you sign up to our sort of newsletter, you'll hear first about when that's happening to be able to keep up to date with the changes that are going on. But having sort of talked about that compliance and sort of legal things, I want to sort of move now on to the rest of the session, just talking about some of the typical employment situations. And I want to start with performance and performance management. And when we talk about performance management, what we really want is for our managers within our organisations to be able to work with individuals and manage individuals in such a way that what we're looking to achieve is good performance. So the emphasis should always be on how do we get good performance. And when we talk about performance management, broadly speaking, that's when, you know, we expect the line manager on behalf of the organisation to be able to let the employees know what's expected of them in their role. So typically that will be their performance. So what are the outcomes of their job that we're expecting? But also it could be behaviours. So it could be, you know, how we expect you to work in line with our values. It could be our competencies. It could also be standards that are set in things like attendance, you know, dress codes that might be articulated in handbooks. So it's about the line manager being able to explain to staff what are the expectations that the organisation has, to consider any development that the individual might need to help them meet those expectations, to monitor the performance of the individual. Again, are they meeting expectations? And to be able to provide feedback to them on their performance. You can think of that more simply as thinking that an employee wants to know three things. Firstly, what's expected of me? What do you want me to do? Secondly, how am I doing? And thirdly, what does that mean for me? You know, so am I going to be rewarded? Is there underperformance that needs to be managed? So if you think of it broadly as those three questions: what's expected of me? How am I doing? What does that mean for me? And as a manager, you want to be able to answer those questions for your employees. And when we've got good performance at an individual level, that can obviously help us drive team performance. That can obviously help us drive organisational performance. So that focus on these performance discussions with that one employee can have real impacts across the whole sort of organisation. So looking at managing performance, it's really something that you want managers within your organisation to be doing daily. And it starts before you even start recruitment and selection processes. And that's really through identifying what your clear role expectations and other organisational expectations are. And you start that through developing your job descriptions and your person specifications. Your job descriptions, your person spec, you're identifying the expectations you have in terms of performance and delivery within the role. That can often be supplemented, as I said, by organisational expectations around things like attendance, you know, values, how you work, that can often be set out in things like contracts, policies, handbooks. You'll then recruit to those expectations. So you align your recruitment and selection to those expectations. So you'll have a process of hopefully selecting the candidate that best meets those expectations to do the job. Once they've started employment with you, then typically you'll go through an induction program to familiarise themselves with the role, the organisation, their team, you know, processes and procedures. So once that initial induction is done and through the probation period, then normally that's when you kind of start that more regular monitoring of performance and progress. So you might set some initial probation objectives. You're probably going to have discussion with the individual about training needs to identify and deliver training. You know, if there are any concerns that arise during that probation period, trying to discuss those to agree, you know, give regular feedback, agree what's needed to perhaps to improve or whether they need more training, to then get to hopefully that formal review period at the end of the probation, where if the individuals reach the sort of the expected standards, that their appointment is confirmed in writing. If not, and there are concerns about the performance, then you could look at what needs to happen at that point. Is it an extension of the probation period with sort of development plans put in place? Or do you get to a point where either through that extension or at the end of the probation period where it's likely that the individual can't meet the requirements of the role, and that you work to bring the employment to an end? So, you know, there are ways that probation period should be structured. And once somebody hopefully has passed their probation period, then typically they'll move into any of the ongoing performance discussions that you have in place within the organisation. So that could be, you know, regular supervisions that you have. It could be quarterly or annual discussions in regard to performance if you set objectives. So it's typically just moving into that sort of more regular ongoing performance management discussion. And having that kind of process in place and making sure that you are thinking about those three questions: what's expected of me? How am I doing? What does it mean for me? And that as a manager, you're having those discussions with the individual regularly to feed back on their performance. It gives you then the opportunity, if there are issues or concerns with potential underperformance, that they can be discussed and essentially nipped in the bud more quickly rather than being left to grow. You know, otherwise it snowballs and can become a much bigger, much more time consuming process for you as a manager to deal with. But if you do have those issues where there is potential underperformance, then there's really a couple of things that you need to do. The first is understanding why. What type of underperformance are you looking at, which will then guide you in terms of what's the process that I should follow from here. So this is really about identifying, is this a capability issue or is this a disciplinary issue? The easiest way to think about those is for capability, we think of can't. So the individual can't meet the level of performance that's required for the role. Now, that could be potentially typically due to two things: illness or injury, or sort of lack of skills and knowledge. Illness or injury, we'd probably think of as ill health capability. Now, that in itself, I would say, if you feel that you've got a situation of ill health capability, I would suggest that you take professional guidance. So, you know, come to somebody like us as HR advisors to help you through that. If it's can't because it's based on insufficient skills or knowledge, then that's an opportunity for you as a manager to think about how you can work with that individual. And you may have a capability procedure that sets that out to improve that knowledge and performance. So that's more performance capability rather than ill health capability. But you need to establish if it's capability or disciplinary. And disciplinary we think of as won't. So that's typically areas of misconduct, potentially gross misconduct, which could be, if you think about it, it's more willful behaviour. It's somebody perhaps choosing not to do something. So that could be you know, conduct issues in the fact that it might be in regard to their behaviour. It could be conduct issues in regard to their job performance if they willfully chose to not do something that they had been asked to do, you know, so they didn't follow a sort of a reasonable instruction. So you need to establish, is it can't or is it won't? And establishing, the way to establish that really starts to come under point 2 and steps to address underperformance. That initial conversation that you have with the individual is around identifying the specific underperformance you want to talk to the individual about. So we'd always say this is a feedback conversation. You want to have relevant sort of evidence or information to discuss with the individual. Discuss it in a timely manner, so don't leave it too late to discuss with them. Highlight the concerns that you've got. So, you know, this is the area of underperformance that I've seen or witnessed, or, you know, if it's a document you've received. And that's the point that you would have a conversation with the individual to understand what's the root cause of that. Why has that happened? And it's that discussion that's going to allow you to understand, is this a can't, is this a won't? So is this a capability issue or is this a disciplinary issue? That will then guide you on what's the appropriate process to follow. And if it's, as I say, ill health capability, then I would signpost you at that stage to sort of professional guidance. If it's performance capability, so if it's due to lack of skills or knowledge, or perhaps even if it was down to a lack of awareness, so I didn't know that I had to do X, Y, or Z, then what you can typically do at that stage is look to agree what we would think of as a performance improvement plan for the individual. So in that you'd set out, clarify what the expectations are, perhaps discuss, identify, deliver any support or training that the individual might need to help them enhance their skills in that area. Monitor progress, so you might set, you know, 4-week, 12-week period through which performance is going to be monitored, and then you would have a conversation with them again at the end of that monitoring period to see whether their performance had improved or not. If it had improved, you probably want to keep monitoring that again for a short period so that you've got a consistent level of improvement rather than sort of an up down, more roller coaster type improvements. If there's been no consistent improvement, then it may be that at that stage you want to move forward with more formal processes. And again, you may have a formal capability process that you would start to go through at that particular point in time. If you're moving into formal processes and you don't have a policy in place, you're unsure what to do, then again, I'd signpost you to professional support at that point. But typically there would be a formal, again, stepped approach whereby You would meet with the individual to discuss the areas of underperformance, agree, again, further improvement plans. If it's formal at that stage, you might be issuing what we would typically consider of as formal warnings. And that sort of may escalate if there's no improvement in performance. You may go through further formal meetings. So you may get to a point almost like a ladder where you get higher levels of warnings, and there may come a stage where it becomes clear that the individual can't carry out the role that you employed them to do. And you'd need to consider if there's any other roles that they can do broadly similar in the organisation, you know, and it may well be that if not, then it might be necessary to dismiss the individual, and you would dismiss them with notice in that situation. But that's why we always say it's really important to nip things in the bud. So those regular performance conversations and feedback sessions with individuals are really important. Thinking about time off, we've touched on, as we talked about minimum compliance, some of the types of leave that are available and required in majority of cases. So I'm not going to talk about them in any greater detail here, just wanted to include this slide basically so I could signpost you through the links that are on here to other guidance, more detailed guidance around things like annual leave, statutory sick pay, family leave, and other types of statutory leave, in case these become situations that you are dealing with employees in the organisation. But what I did want to touch on was just sickness absence and kind of managing sickness absence. Again, this can be a sort of a recurring situation for organisations. So this is where it might be helpful for you to think of having some kind of process for managing sickness absence set out within a policy. But typically we say that managing absence should, or monitoring absence, I should say, should happen on an ongoing basis. And if you already have a sickness absence policy in place, you may have what's referred to as trigger points within it, which set out what are acceptable levels of absence for an organisation. That may give you, as a manager, a sort of a consistent approach to monitoring and discussing absence with individuals when you reach a trigger point. If you do reach a trigger point, or it becomes apparent to you as a manager that there is an unacceptable level of absenteeism, perhaps there is a long-term sickness absence, or there's a recurring pattern of sickness absence, then you may want to discuss that with the individual. Now, normally that approach is not about, you know, questioning the genuineness of the absence, but it's about looking at, you know, the disruption and the impact that it can have on the business when you're sort of accommodating, you know, sort of persistent short-term absence, long-term absence, or kind of, you know, cases of recurring absence. Now, we have a full webinar, and again, I've included a link on this slide to our webinar, which is about managing sickness absence. So that goes into a lot more detail on the approach. But typically, and again, it might depend on the situation and your policy, if you've reached that point of concern, or you've reached that trigger point within a policy, then you're going to want to have a conversation with the individual. You know, you might be continue to monitoring the situation. It may be that you want to seek some medical guidance. That can be really helpful if you've got recurring illnesses, if you've got a long-term illness, if you've got something where the individual is saying that perhaps it's stress and that's related to work. It'd be really helpful to get medical guidance and medical input, you know, again, with the agreement of the individual concerned, because that can help you identify any adjustments that might be either required in law or might be beneficial to improve the absence. And as we touched on with capability, you might put in place an improvement plan, and we would refer to these as attendance improvement plans. And that could be, you know, a period of time over which, you know, you agree what an acceptable or an improved level of attendance would be. In addition, you know, when you're managing sort of ongoing, you know, any period of absence with an employee, It can be really important to do return to work interviews after absence, again, just to understand if there's any underlying conditions, if there would be any benefit from getting occupational health or medical guidance from the GP. And if you're looking at things like long-term absence, it could be helpful to look at things such as phased return to work. If you've got a policy might set out an approach to long-term absence, and we would typically think of anything 4 weeks or longer. And steps, in terms of managing long-term absence might include getting medical guidance. It might include sort of, updates, discussions with the individual in regard to their long-term absence. But again, we kind of say, if you're getting into formal situations of managing sickness absence, or you're dealing with long-term sickness absence, then you may want to take formal or professional guidance at that point. But if you're just looking for some guidance around, well, how do we manage sickness absence more informally, then I would signpost you to our webinar in the first instance, and you can use the link on this slide to access that. Again, around sort of, typical employment situations, quite often you will be dealing with requests for flexible working. Now, there is a statutory right here, but it's the statutory right to request flexible working. It's not a statutory right to work flexibly. But if you receive a request, a flexible working request, and that could be, for example, somebody asking to vary their hours, it could be that they're looking to vary where they work, then you do have a process that you need to follow. And there is a code of practice, an ACAS code of practice. Again, I've signposted to ACAS in one of these slides, but there is an ACAS code of practice that sets out the process that you need to follow and the 2-month timescale that you have to deal with requests for flexible working. But key things in terms of flexible working requests, there's no length of service requirement. So from day one, in fact, probably pre-day one in recruitment and selection, people can request flexible working. They can make up to 2 applications in a 12-month period. They have the right to appeal against the decision, for example, if you reject the request to work flexibly, and just say you have a 2-month timescale for handling requests. Again, I've linked to a fact sheet. That fact sheet, the managing requests for flexible working fact sheet, we will send out along with copy of the slides. But there is a fact sheet and there is guidance from ACAS that sets out what the process is. But the key things for you to be aware of at this point, it's a statutory right to request, and there is no length of service requirement needed. There used to be, there is no longer. And an individual can make up to 2 applications in a 12-month period. If you are looking to refuse a request for flexible working, you have to meet with the individual before you refuse the request. And there are only 8 statutory reasons why you can refuse a request for flexible working. Again, those are all set out in our fact sheet, but also by the ACAS code of practice. My last sort of typical situation is around changing terms and conditions. And obviously this has a big caveat around the changes that are going to come into play with the Employment Rights Bill through sort of fire and rehire. But essentially, if you're needing to seek agreement to vary terms and conditions for your existing employees, the first thing you need to do is check your contract. So firstly, can you make a contract, or can you make a change without varying the contract? Actually, is it a contractual change that's needed? If it is a contractual change, then have a look at the clause that you've got in your contract. Does it enable you to vary certain terms without having to consult staff, or do you have to go through a sort of a full consultation process? And sometimes determining the level of consultation might be around the reason for change. If you were implementing new shifts, if you were looking to reduce pay, that kind of thing, then it's highly likely you're going to have to consult on that level of change. If you're consulting, you need to develop a business case. What's your rationale for change? And you need to go through a meaningful period of consultation with the affected employees with a view to seeking their agreement. to the change. But what we need to be really mindful of is the fact that actually you are unlikely to have the last resort of issuing a notice of dismissal and offering a new contract on the new terms moving forward. So it may be that if you're looking to vary terms and conditions in the future, you have to look at ways to really engage people in the process, consider any of the alternates they bring to consultation, perhaps offer sweeteners for the changes, you know, to get to a point where people do accept those changes. So again, I've signposted you to some of the free support here that you can access through us, guidance and HR consultancy through Roots, to the government website where there is some helpful information, and also to ACAS where again there's guidance and there's also some codes of practice that are really helpful for you to follow. So I'm just going to check and see if we've got any questions in Q&A. It looks like we have. So I'll have a look and see if there's any questions that are very, very specific, because I'm conscious of time as well. Then I may suggest that you take advantage of our 1 hour free HR consultancy and ask us the question there. New starters who are joining partway through the year, clear on pro rata for annual leave, but confused about bank holiday. Are new employees only entitled to bank holidays that occur in the year after they join, or a pro rata of all bank holidays over the year? You would likely, you offer 25 days leave plus bank holidays. What I would suggest is it's going to be simpler to offer a pro rata of all bank holidays over the year. So simply look at that as being 33 days leave and pro rata that to the period of the year that they're going to be working, because otherwise you're going to have to do a very messy calculation on some 28 days and then remaining 8 days, which I would say is probably going to become administratively difficult for you to do, and it would make more sense to do a pro rata of all bank holidays over the year. Question, is this the same for someone on a 1-year contract? I'm not sure what that relates to. So Lisa, if you want to pop some additional information in there, or alternatively, you can use our 1 hour free to ask a question. If someone has had successive fixed term contracts for several years, do they then become a permanent employee? Yes, they can do. And the sort of time period for that is typically 4 years, unless there is a clear and reasonable justification for why they need to remain on fixed term contracts. Then typically, once you've hit that 4 years, then yes, they would be considered permanent. Okay, let me just check chat just to see if there's any questions that have gone into chat. No, doesn't look like it. I can't see anything else coming in Q&A. So if there's no other questions, then we'll finish there. And yeah, if there is anything else, as I say, you know, we'll send through a copy of the slides. And they've got all these links on here, and we've got all of our contact detail on here. But if there are any questions, then as I say, we do offer up to an hour of free HR consultancy to social sector organisations. So obviously, if you haven't used that previously and you've got questions, then we'd be more than happy to go through those with you through that 1 hour free. And the information on our website will set out how you can get that 1 hour free. So yeah, any other questions, please do ask those through that. I'm just checking. There was just a question come through. Is it Zinzi? Just joined with the disability, who's asked about a disability leave policy. Do you know of any examples? I don't know of any examples, no. But if they have medical appointments at regular intervals over the year where they may need time off after, I would suggest that you consider that as a reasonable adjustment. Again, you could take advice from us via the 1 hour free or have a look at ACAS, but I would just suggest that individually you would consider their disability, consider their additional requirements for medical appointments, and probably highly likely agree that as a reasonable adjustment. Thank you so much for your comments in the chat. I'm glad that it was a really useful session. I'm conscious people are dropping off because of time, but as I say, we will send through a copy of the slides so you've got those links and a couple of the fact sheets that I've referred to. And yeah, and as I say, have a look on our website, loads and loads of free resources on there, and do keep in contact with us so that we can continue to update you on the Employment Rights Bill as it continues. Thank you all. Take care. Bye.